This is Barry Zalma on insurance. I am an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant or expert witness, an author and producer of these videos. Today, at the request of one of my listeners, we move back to first-party property insurance and the duties and obligations of the property adjuster. Although a special relationship exists between an insurer and insured because they are in privity of contract as an individual, the individual insurance adjuster is not in privity with the insureds based on the insurance policy wording. Thus, although the employee adjuster does not owe a special duty to the insureds on which the bad faith tort could be based against the adjuster, he or she owes the duty to the insurer employer. Although actions of the adjuster can support a claim of bad faith against the insurer for whom the adjuster works. Consider Grunberg versus Aetna Insurance Company, where the insurance adjuster falsely reported to the local authorities that Mr. Grunberg had committed the tort of fraud and had intentionally caused a fire to his premises, although there was no evidence effecting or proving that allegation. As a result, California instituted for the first time first-party bad faith. In the absence of privity of contract, an insurance adjuster was found not to be individually liable to the insured for a failure to settle the claim or for the adjuster's wrongful acts in the Grunberg case, but the insurer for whom he worked was found to be responsible and was found to have acted in bad faith. The actions of an adjuster can therefore cause the insurer that employed him or her to face charges of breach of the insurance contract and liability for breach of the tort of bad faith. Texas courts note that an adjuster is a person subject to the requirements of the Texas Insurance Code with regard to acts undertaken in the business of an insurance. An independent insurance adjuster, on the other hand, is not liable to an insured for malfeasance when the insurer delegates to the adjuster the responsibility to handle the insured's claim. Because the adjuster is not in a contractual relationship with the insured. Grunberg held that an insurance adjuster and law firm hired to adjust the claim were not liable for bad faith. In Sanchez versus Lindsay Morton, a 1999 decision of the California Court of Appeal, an independent adjuster hired to adjust a claim was found to owe no duty to the insured individually. However, in Texas, the Texas Supreme Court determined that the adjustment of claims and losses qualifies as the business of insurance, thus making an adjuster a person under the Texas Insurance Code. Consider Vail versus Texas Farm Bureau from 1988 and Gash versus Hartford, a Fifth Circuit decision of 2007 that held that any insurance adjuster who services a policy engages in the business of insurance and therefore could be held individually liable under the Texas Insurance Code. Regardless of the jurisdiction, the adjuster must conduct himself or herself in such a way that there will never be an issue that the insurer breached the contract directly or through the adjuster's actions. Although protected from individual tort liability in almost every state, an adjuster acting in bad faith exposes the insurer to a bad faith judgment and will probably cause the adjuster to lose his or her job. Imposed on the adjuster by the insurer and by state law and regulation is an obligation to investigate the loss, interpret the policy wording, and apply the policy wording to the facts discovered in the investigation. A first-party property adjuster must therefore be educated, trained, experienced, and ready to help an insured obtain the benefits promised by the insurance policy. Failure to do so, failure to train, can do nothing but cause problems for the insurer that hires a less than well-educated, trained, experienced, and ready to help insurance adjuster. In a case called Moon Keodala versus Allstate, the Court of Appeals of the State of Washington in 2018 found that an adjuster could be personally liable for tort damages incurred by an insured as a result of what the state found to be bad faith conduct. The case was, fortunately for adjusters doing business in the state of Washington, reversed. The adjuster does not act as an attorney for the insurer or for anyone else, although some of the things an adjuster does is like what an attorney might do. Those things that the adjuster does in anticipation of litigation, such as when the investigation indicates fraud or a loss for which no coverage is available under the terms and conditions of the policy, any effort to expand the work product doctrine to include the work of the insurance adjuster prior to retention of counsel requires a deliberative and participative process to assure a careful balance between advocacy and truthfulness. The routine taking of statements by an insurance adjuster is work in the ordinary course of business and fails to qualify as work product. The Idaho Supreme Court has indicated that statements made to an insurance adjuster can be work product and protected from discovery under appropriate circumstances. In Dabastani versus Belus, a 1998 decision of the Idaho Supreme Court, it agreed that a statement made to an insurance adjuster was protected as work product and free from discovery. The work product objection is the type that could be made during a deposition as questions are presented and does not prevent the deposition of an adjuster. To make certain that the adjuster's work is protected by the work product doctrine, it is necessary that he or she be instructed by counsel and that the work is in anticipation of litigation with an explanation from counsel why it needs to be protected. And that is why first-party insurance claims controlled by a lawyer, or at least advised by a lawyer, makes that lawyer a necessary witness in any subsequent trial, and therefore that lawyer should never act as trial counsel if, after advising an insurer to, among other things, deny a claim, that insured sues, because the lawyer will be a key witness, as will the adjuster. If litigation is not anticipated, the adjuster, after being assigned a first notice of loss caused by fire, lightning, windstorm, hail, or any other peril not excluded by a direct risk of loss policy, must begin work to complete a thorough investigation. The adjuster must understand that it is his or her obligation to determine if the loss is one for which the insurer promised to provide indemnity, determine if the conditions of the policy have been complied with by the insured, and reach agreement with the insured as to the amount of loss and the amount of claim compensable under the policy. And that is why they're called adjusters, because they adjust the difference between the actual loss found by the insurer's representatives and the loss claimed by the insured. And working together with the insured, the adjuster concludes a claim fairly and properly with the insured. To fulfill the duties imposed on the first-party property adjuster by the policy and by the requirements of the insurer, the state where he practices his or her profession, and the regulations that control the adjuster's work, the adjuster must first read the policy, because it is impossible to deal with a first-party property claim without first reading and understanding the terms, conditions, and limitations of the policy. Next, the adjuster must analyze the policy wordings to conclude that the words of the policy are sufficient to provide coverage to the insured for the loss claim. Then, before beginning the investigation, the adjuster must read the loss notice, because this is the provision of the policy that must be complied with by the insured to tell the insurer what happened, when it happened, and how it happened. And with that information, the adjuster can have sufficient knowledge to begin the thorough investigation required by law. Next, the adjuster must meet with the insured and all witnesses, either in person, if the loss is sufficiently large to require in-person investigation, or by telephone if it is a simple and small loss. Every first-party property investigation should consist and include a recorded statement of the insured and any independent witnesses, whether conducted in person at the loss site or at a reasonable location or by telephone. The recorded statement is essential. And if for any reason there is a question of coverage, the recorded statement should be transcribed, sent to the insured to be read, corrected, and signed before a notary or under penalty of perjury. The insured should be advised of the insured's obligation to submit a sworn statement in proof of loss, and a blank form should be provided to the insured on every claim. Whether that blank form will be required to be filled out only by the insured or later with the assistance of the adjuster if there is no question about coverage or the amount of loss. Often insureds retain the services of public insurance adjusters, and the adjuster working for the insurance company must be aware of local statutes relating to public insurance adjusters and be ready to deal with the public insurance company as if he is the insured or she is the insured, in such a way that a fair and reasonable resolution of the claim can be met. Public insurance adjusters are often professional and should make the work of the company's insurance adjuster easy if they are professional and honorable people. Finally, the adjuster must obtain all relevant documents, negotiate a settlement with the insured or the insured's public adjuster, create an agreeable proof of loss and statement of loss, and resolve the claim in its entirety. This video was adapted from my book, The Compact Book of Adjusting Property Claims, 2nd edition, which is available as both a Kindle book and a paperback from Amazon.com. If you found this video to be useful, please forward it to your colleagues. It's free. And please subscribe to my Rumble channel, where you will find more than 90 of these videos, and my YouTube channels, where you will also find many videos, over 90 in total. Please also subscribe to my blog so you can learn about future blog postings and videos. Thank you for your attention.